All right, the judge and private court of justice.
All rise.
You can call the case.
Caribbean Court of Justice, original jurisdiction for delivery of reserved judgment in CCJ application number GDOJ2018-002 between David Bain and the state of Trinidad and Tobago. The panel before you today comprises the Honorable Mr. Justice Witt, Mr. Justice Hayton, Mr. Justice Anderson, and Mr. Justice Burgess. Can we have the appearances, please?
May it please, Your Honors, from Grenada, Ruggles Ferguson for the record, appearing along with Mr. Patrick Superville for the claimant applicant, David Bain.
May it please Your Honors, for the state of Trinidad, Mr. Sean Julian
Thank you. This is a judgment of the court. Oh, sorry. Yes. Guyana?
May it please Your Honors, I'm Sandra Bart, and this is Mr. O'Neill Francis, and we are led by Dr. Corlita Back-Schiffer. We appear on behalf of the Caribbean community.
Thank you very much. I didn't see you on the screen, so that's why I almost forgot you. This is a judgment of the court. In the original jurisdiction, there are no judgments of separate judges, as you know. Usually the judgment is read in a summarized form by the presiding judge, but given the fact that this will be the last time that Justice Hayton will be part of this original jurisdiction, I suggest we leave it to him to read the judgment.
Thank you, Mr. President. First of all, a reminder, of course, that this summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. The claimant was granted special leave pursuant to Article 222 of the revised Treaty of Tragaramas, the treaty, to bring a claim against the defendant, Trinidad and Tobago, to enforce his right to freedom of movement as clarified by this court in Shannick Maori and State of Barbados No. 2. The claimant is a citizen of both Grenada, where he was born, and the United States of America. On Thursday, 14th December 2017, he traveled from Grenada to Trinidad and Tobago on a Liat flight. Prior to the arrival of the flight, officials in the immigration office at the Piarco International Airport had been formally provided with information relating to drug offences being detected against the name of a man called David Bain on the Advanced Passenger Information System. The claimant arrived at the Piarco International Airport around 11:50 p.m. and presented his completed immigration form supported by his USA passport. After interviewing the claimant, and despite his strenuous denials as to any drugs convictions, he was denied entry into Trinidad and Tobago and issued with a rejection order. The claimant was informed of his right of appeal but chose not to exercise it, leaving Trinidad and Tobago a few hours later on a scheduled flight to Grenada at 5:45 a.m. on Friday, 15th December. According to the claimant, before the decision to reject him was taken, though according to the defendant after such decision, he informed the immigration officers that he was a citizen of Grenada and so entitled to freedom of movement into CARICOM member states like Trinidad and Tobago. In support of this, he produced his driver's license, which stated on its face he was a Grenadian citizen, and a Grenadian voter's identification card, which stated on its face he was born in Grenada. The claimant also submitted that the USA passport produced to the immigration officers, while stating the claimant's nationality to be that of the USA, additionally stated Grenada as his country of birth. a matter which he alleged should also have influenced those officers to accept he was a Grenadian citizen. The claimant had also held a Grenadian passport, which he did not have with him, since it had expired about 3 years previously, and he had not had time to renew it. On 18th April 2019, however, he was issued with a new Grenadian passport establishing his Grenadian citizenship. It was not disputed that the claimant was a Canadian citizen in December 27 when he arrived at Piarco. The dispute as to whether he actually had sufficient documentation to enable him to establish Grenadian citizenship with the immigration officials of Trinidad and Tobago, thus enabling him to rely upon his relevant treaty rights. As to this, the court ordered a preliminary hearing, since consideration of certain legal issues, if resolved in favour of the defendant, would obviate the need for a costly hearing to determine disputed factual issues. The court first considered whether the claimant waived his treaty rights as a national of Grenada, a CARICOM member state, when he presented himself as a citizen of the USA on his arrival in Trinidad and Tobago. The court noted that a person with dual nationality has two citizenships which exist side by side. As such, the exercise of rights attached to one nationality does not eliminate the right to exercise rights attached to the other nationality. To exercise any of these rights, however, clear documentary evidence is required. The onus of proof is on the intended entrant to show forthwith that he or she is entitled to seek entry as a national of a CARICOM member state with rights under the treaty. In the circumstances, a denial of entry on the basis of the USA passport meant that it remained open for the claimant to claim his treaty rights if he could prove Grenadian citizenship in the absence of producing a valid up-to-date Grenadian passport. The court then turned its attention to whether the claimant had produced conclusive evidence which would enable him to be treated as a national of a CARICOM member state. The court found that the presentation of a Grenadian driver's license issued by the Commissioner of Police and the Grenadian voter's identification card issued by the Supervisor of Elections were not sufficient. The focus function of a driving license and voter ID card was to permit driving or voting in Grenada, not to establish or evidence citizenship. They were not machine readable, nor designed to be stamped with dates of entry into countries. The focus function of a Grenadian passport, on the other hand, was to establish citizenship for very significant international purposes, including assuaging security concerns. The court rejected the contention that the USA passport, by stating country of birth, was capable of conclusively establishing that the claimant was a Grenadian citizen. After all, it was possible that the claimant had renounced his citizenship or been stripped of the same by the relevant minister in Grenada, while mere birth in the country does not always automatically confer citizenship rights. The court relied on the written submissions of the Caribbean community, which explained that the appropriate travel document to invoke the right of freedom of movement is the CARICOM passport or a passport issued by a CARICOM member state. The community further explained that this framework exists for two reasons. Firstly, the CARICOM travel card, the CARIPAS Treaty, which envisioned a regional machine-readable travel card for travel between CARICOM countries by CARICOM nationals, had yet to be implemented. Secondly, the earlier development of having a CARICOM passport bearing the official CARICOM logo as an alternative to individual CARICOM member states' passports had not been followed through by all member states. Based on these submissions, the court concluded that the claimant's submission of his USA passport, his Canadian driver's license, and voter identification card did not suffice to conclusively establish his Grenadian nationality to the immigration officers in Trinidad and Tobago. The court added that given that determination, it did not matter whether those documents were produced before or after the claimant was refused entry into Trinidad and Tobago. The court also dismissed the claimant's fallback position that the provision of sufficient evidence should have put the defendant on inquiry to confirm or refute citizenship. The court reiterated that the onus lies upon an intended entrant into a CARICOM member state to establish that he or she is a national of such a state with the right to freedom of movement. The court noted that the primary function of an immigration officer is to be a gatekeeper, taking only a short time to open the gate to those who clearly qualify to be admitted. The court also pointed out that there were practical problems associated with an immigration officer involved in investigations of law and fact to determine whether or not there is some reason that can or cannot be found to help the potential entrant justify being admitted through the gate. The court concluded that, bearing in mind that under international law, non-CARICOM nationals generally have no right to enter Trinidad and Tobago, whereas CARICOM nationals do have such a right, albeit subject to certain exceptions, the defendant's refusal to let the defendant enter its territory was unassailable. The court dismissed the claims against the defendant and orders the parties to bear their own costs.
Thank you, Justice Hayton. Is there anything you would want to remark? Mr. Ferguson? Mr. Ferguson? Yes. I think we can't hear you. Well, I'm not only thinking that, I don't hear you. Is there anything else that needs to be said?
Your Honour, not from our part. Thank you very much.
Okay.
And might I say on behalf of all counsel, I think, thank you to Your Honour, Mr. Hayden, Justice Hayden, for his contribution to the CCJ, and we wish you well in your future endeavours.
Thank you very much.
Ms. Babshaver? Okay. Well, the only thing I can add to that is to be clear in that the judgment, as I said, was given by the court, which included the president, who is not present at the moment, but who formed part of the panel that gave the decision, as was just summarized by Justice Hayton, in a way that you will probably never hear anymore, because I don't think there's anyone who can deliver a judgment as he does it. And we also, well, we have said that already many times, but we also appreciate his presence on the court, as has been made clear already several times.
Thank you very much indeed.
So then we can adjourn.
All right?
All rise.
Good job.